One. Well, welcome everybody. My name is Scott Kelly. I'm with Black Dog Venture Partners, and thank you for joining our webinar today. I'm going to introduce Brent in just a second, but I'm going to share my screen and go over just a couple of quick notes about myself. All right, you should be able to see my screen. If you can see my screen, just give me a thumbs up. Thank you, appreciate that. All right, let's do this. Go slideshow mode. All right, so again, our webinar today is legal basics for founders raising capital. I'm really excited to introduce Brent, a seasoned professional in the space, and he'll share more about himself in just a couple of minutes. But again, just quickly about myself. Again, I am the CEO of Black Dog Venture Partners. I've been in the startup space as both an investor and entrepreneur for 30 plus years. I've been fortunate to help myself and other companies raise $5 billion in capital, $100 million in sales for our companies. I speak internationally at events around the country and host these kind of webinars. As I said, I'm the host of this event and the CEO of Black Dog Venture Partners. I also host VC Fast Pitch, which is our online and in-person events which connect investors directly with entrepreneurs. And then I'm also the host of our new podcast, the Emerging Managers Podcast, which provides insight and information from some of the top venture capital fund managers in the world. If you got my 3 websites there, you can take a look at that. And I'd love for you to connect with me on social media. You can find me at all channels at Black Dog CEO. I am going to make sure everyone that's on this call, if you do want, we have a number of great startup tools. If you send me an email to Scott@BlackDogVP with the subject line startup tools, I'll send you a pitch deck template, which you can use to create your own pitch deck. I'm going to send you a glossary of investor terms so you know the types of questions, the type of information that investors are going to want to hear. I've got all kinds of free and discounted startup resources. And then I also will invite you to our future webinars and our pitch opportunities like today. So I'm going to stop sharing my screen now, and I'm going to introduce my friend, Brent. Brent is probably one of the most seasoned startup attorneys in the country. And he's been there, he's done that, and he knows this. So with that, I'm going to give the helm to Brent. And what we're going to do is Brent's going to go through some of his slides. I'll probably ping him with some questions from time to time. And then at the end, we'll have an open Q&A. So what I'd like you to do is make sure you're muted during the presentation, keep the chat clean. And then what I will do is after Brent and I are done speaking, having our presentation, we'll open it up for Q&A. So with that, I'm going to give the helm to Brent. Welcome.
Thanks, Scott. Thanks a lot, man. Scott, can you see my screen?
Yes, I can. You're perfect.
Okay, and that, again, you're looking at the Brent Britton legal screen just to make sure, not the one with the index, right?
Yep, you're good.
Excellent. All right. Hi, everybody. It's great to be here. My name is Brent Britton, and my law firm is Brent Britton Legal. I've been representing technology startups for 31 years, and like Scott, having done it this long, I've raised hundreds and hundreds of millions of dollars of investment capital or overall deal transaction value in the M&A space. If not billions. By practice, it largely consists of formation to exit representation of the technology startup, which means everything, capital transactions, intellectual property, commercial transactions, you name it, I pretty much do it. Today, we're going to talk about some legalities of the startup funding process. This is a presentation that is most directly suited to the naive or first-time entrepreneur. If you've done it before, if you've raised capital before, started a company before, certainly had an exit in your past, you probably know a lot about what I'm going to talk about, but there may be some gems or two that escaped your attention last time through. So we have an hour. I guess we're already 9 minutes in. Let's hold the questions until the end, I guess, Scott, or although you can manage that as you see fit, and I'll get going. All right. So the point of a startup in the early stages is preparing everything for investors and exit, at least the legal side of the company. And obviously, you've got to be working on operations. You got to be building your product. You got to be taking care of a whole lot of things, and that's really the universal truth of the entrepreneur, is that you're doing a million things at once. You're paying attention to, you're the janitor and the bottle washer and everything else, taking out the garbage. So You've got a lot to pay attention to. You can get distracted very easily. You can get pulled into, Johnny stealing magic markers, or somebody came to work drunk or something like that. All things that you, as the leader of your company, need to pay attention to. But I'm here to tell you that if you want to get investors and you want to get to an exit, then the legal side of your company is something that you need to pay attention to. The legal problem is worth solving. This woman, the unnamed age 35 resident of Bullitt Avenue in Roanoke, worries about the effect on her unborn child from the sound of jackhammers, but not the cigarette that she's smoking there. Somebody who's paying attention to the wrong problem, and you don't want to make that mistake. So here's my first bit of advice. Form your company early. If you are conducting business, you should be doing it within the confines of a formally formed a business entity, either a corporation or a limited liability company. We're going to delve into the difference between those things momentarily. Why do we form companies? Because you're going to get sued, because that's what happens in business. You do something wrong, or you're perceived to have done something wrong, and somebody threatens or eventually does go forward and files a lawsuit against you. If you have formed an entity, then you personally are not liable for the harms occasioned by the business, okay? The business itself is the target, is the defendant, is what gets sued, and you as the owner are shielded from the business's liability. That's why we form companies in the United States, and I dare say throughout the world, is to shield the owners from liability. So let me be clear. When a company gets sued, its shareholders are not at risk in terms of being named defendants unless they participated personally in the activity that got the company sued. So if you're off the reservation doing stupid things, yes, you personally might be involved in that lawsuit. But for the most part, you as a mere owner of a company are not a proper defendant in a lawsuit for harms caused by the business. So get that done first, because you're going to be out there, you're going to be conducting business, you're going to be shaking hands, talking to people, bringing in co-founders, possibly future customers, all kinds of things. And that's business. That's the conduct of business. And those are the things that can get you sued. Fortunately or unfortunately, your business partners, your employees, the people you're working with are the most likely plaintiffs in your future, because they're who you're involved with on a day-to-day, and they're the ones who are most likely to perceive themselves as having been harmed. So I can't stress this enough. You have to form your company early. Now, you do have to choose your type of entity. Is it going to be you've heard of a C corporation, an S corporation, an LLC. You might have heard of a B corporation, for example. It's not always easy to figure out which entity to form as you're going to form your company. And the decision can be somewhat maddening. I can simplify it for you, and I will presently. But before we talk about corporate formation, we have to talk about trademarks. Why do we have to talk about trademarks so early in this conversation? Because if you're going to form a company in any state in the United States, you need to give it a name. That's how the Secretary of State tracks your company, with its corporate name: XYZ ABC WYSIWYG Inc. 123 ABC Corporation, what have you. And just as a matter of trivia, there can only be one company with a particular name per state. Okay, so there's one index, and if that name is taken, you can't name your company that name. That has nothing to do with trademarks. That just has to do with the way the secretaries of state identify your company. So there can't be multiple companies in any state with the same name. So you have to name your company, and you also need to brand your product. And I think it's a good idea if the name of your company is very similar to, if not identical to, the brand of your product. Look at Uber, for example. The app is called Uber and the company is called Uber. And that just reduces the cognitive load on your customers and people who are trying to find you. Obviously, there are companies like Procter & Gamble that have numerous brands like Tide and Cheer and Gain and all that. And when you're that big, you can make those decisions. But for the most part, your name of your product should be similar to the name of your company, if not the same, which means you do have to worry about trademark risk. So before you form a company, you got to think of your name, and then you need to have someone like me perform a trademark risk analysis on that name to make sure that you can use it in commerce without getting sued for trademark infringement. Why would somebody sue you for trademark infringement? Because your brand name is confusingly similar to their brand name, and they're afraid that you're going to divert business from them to your customers.
So Brent, I had a question and maybe some examples. It was really interesting. Many years ago, I registered the domain Arizona Realtor a guide. And I actually got a cease and desist letter from the Arizona Department of Realtors because even the domain name violated, their brand, their trademark. So maybe you can share even something as simple as a domain can have a real negative consequence if not, vetted this process. Would that be
Yeah,
a fair
no,
statement?
yeah, you have to be careful, right? Realtor is a weird one because you can only use the word realtor if you are one. So there's even a different issue there with respect to the trademark. But yeah, I mean, if first of all, it's really important that you understand that obtaining the right to a domain is not a trademark. Okay, you don't own a trademark just because you got purplemonkeyvolcano.com. That doesn't give you any trademark rights. If somebody else owns that trademark, Purple Monkey Volcano, they can come take that domain from you because your domain, your use of it could potentially infringe their existing trademark. But you don't obtain any trademark rights just by getting a domain name, and you don't obtain any trademark rights when you form a company, because as I say, when you form a company, you have to name it, you send that name to the Secretary of State, the Secretary forms your company. Big deal. That's not a trademark. You don't get a trademark until you start using that brand name in commerce as the name of your company, as the name in your advertising, as the stamp on your product, as the splash screen on your software, what have you. That's the trademark use. So the point here is, can't form a company without naming it. You can't pick a name without doing the risk analysis to make sure that that name is relatively low risk and you can get a registration on it, and you can not get sued by other people when you introduce it into commerce. So don't fall in love with your name. When you pick your name, be sure that you go to someone like me to do a trademark risk analysis, and be prepared to change it. Okay, I've had clients come to me, and I had a guy the other day who wanted to do a particular tool and have it shaped like the Nike swoosh, and he wanted to call and then he wanted to have his tagline be something similar to just do it. I'm not giving you the actual details in light of the attorney-client privilege, but that's just blatant trademark infringement, right? I mean, you're calling to mind the existing trademarks of an existing company, and that's the nature of trademark infringement. So don't do that, and be prepared to change your name if a lawyer like me tells you that it's too risky. Okay. All right, let's get back to types of corporate forms. So there's a bunch, right? There's a sole proprietorship, a general partnership, a limited liability partnership, a limited liability limited partnership, and a limited liability company, and a corporation. Now, you don't have to really pay attention for the purposes of this presentation to any of these. I will tell you, however, that as I said earlier, if you are operating without a company, if you haven't formed a company, then you're conducting business without the liability shield. If you're alone, you're a sole proprietor by definition. If you're in concert with others, if you and me and Scott and a few of us get together and decide we're going to do business together, and we go out and we start doing stuff in furtherance of that business, but we don't form a corporation, congratulations, we have just formed a general partnership. And what's interesting about a general partnership is that every partner is personally liable for the harms caused by any of the other partners. So if you're out there in business shaking hands with folks saying, hey, you go get that customer and I'll build some software and yada, 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 and you don't form a company, you formed a general partnership. So if that guy or gal on the way to that business meeting has too much to drink and runs off the road, kills a baby, congratulations, you're going to be liable for that jointly and severally. So don't do that, okay? Form a limited liability company or a corporation. And I'm here to tell you now which one you should form, okay? And I'm going to dramatically simplify this issue for you because there are a lot of reasons to do this, that, and the other thing, but what it really comes down to is if you're not going to be pursuing professional venture capital or serious angel money, then just form a Florida S corporation or a Florida LLC. They're very simple. You can form it locally. You can go to sunbiz.org and do it yourself. And you can be perfectly fine. If you are going to be pursuing professional venture capitalists or serious angels, then form in Delaware and form a Delaware corporation because investors are going to want to see that when they start to take a look at you.
So, Brent, let me touch on that for a minute because, and again, obviously we're talking to an audience from around the country. So obviously, if you're not from Florida, obviously you can consider your local state, and if you're a company, you get that. But I really want to reiterate what Brent's saying, because I talk to literally hundreds of investors every month, and I talk to hundreds of entrepreneurs every month. And and Brent, you can add some flavor to this, but it's relatively easy to set up an LLC. But the vast majority of professional angels and venture capital firms simply will not invest in LLC because there's anything. And Brent, you can talk to your tax advisor, your attorney, but there's tax consequences, there's formation consequences, several things that preclude investors and investment groups from investing in LLC versus a C corp. Any flavor you want to add to that, Brent?
Yeah, absolutely, Scott. You're entirely correct. If you're in Arizona and you're not pursuing VC, go ahead and form in Arizona. And I should say, by the way, if you are from a foreign country, everything I'm saying today applies only in the U.S. Every country is going to have different laws with respect to all of this stuff.
Now, and again, one thing I want to talk to also to our foreign participants. Again, if you want to pursue U.S. angel investment capital or venture capital, you're more than likely going to have to still have an entity that is a Delaware C corp.
Oh, there's no question. There's no question about that. You may have a thriving company in Sydney, Australia, but you will not obtain American venture capital deals unless you put a domestic United States entity here, move the assets here, and that company and the profits from that enterprise stay patriated in the United States. So yeah, you need to have a U.S. footprint if you want U.S. investors. So why the corporation and why Delaware? And just let me finish that tag off real quick to say that either way you want to get good governance documents, and I'm going to talk about all those in a minute. The primary reason that investors like to invest in a Delaware corporation is because Delaware has a very ancient system of corporate laws and a special court, in fact, that's dedicated to corporate and shareholder disputes. It is a very well-balanced set of laws that give both shareholders and management sort of equal power in the governance of the company. And since the investor is going to be a shareholder, they enjoy the ability to use Delaware law because it gives shareholders significant rights, including minority shareholders, which is the thing you may have heard of that Elon Musk was complaining about a few weeks or months ago, that a majority shareholder in one of his companies was able to exert sufficient control that he was unable to consummate a deal without their approval. And so he decided to leave Delaware and go to Texas, I believe. So when you're Elon Musk, you can decide where you want to put your corporation as well. But if you want venture capitalists to pay attention to you today, you got to do a Delaware corporation. A little bit about nomenclature, and we'll get to this in just a minute. There's really no such thing as a C corporation. It's just a corporation, okay? A corporation is a corporation. A corporation can take the S election. The S election is a tax filing. I'm going to talk about it in a few minutes. There's really no, we call them S corps and C corps, but just between you and me, it's a corporation, one of which happens to have taken a tax election called the S election. All right, so here's your governance layer cake. This is sort of how a company is governed. If it's a corporation, it has shareholders. The shareholders are the owners of the company, and they vote at shareholder meetings to elect the board of directors. The board of directors actually runs the company on a day-to-day basis, makes decisions as to the direction of the company, and doesn't really go to the shareholders for permission to do a whole lot of things. The board of directors is empowered with the ability to choose the strategic direction of the company, and to hire and fire the officers of the company. The officers are the people actually in the company doing the work every day, and they serve at the pleasure of the board. The board of directors is the boss, if you will, of the officers. Now, in the beginning days of your company, you're going to be all these people. You're going to be the shareholders, you're going to be the board of directors, you're going to be the officers, you're going to be the employees and contractors. There are only two ways for a company to engage with a worker, and that is either as an employee or as an independent contractor. There's really no other way to classify them legally, and the difference is important, and you need to pay attention to it. Primarily, the difference is that everything created by bona fide employees automatically belongs to the company. Everything that created by independent contractors automatically belongs to the independent contractor unless there's a written agreement that says the company owns it. So you have to be very careful when you're engaging independent contractors that you have the right agreement in place. This governance layer cake at the LLC level, it starts with the members, who are the owners of the company, akin to shareholders, and then the managers, who are both the officers and the board of directors, if you will. And then, of course, employees and contractors. So that's just a bit of nomenclature, the difference between corporation and an LLC in terms of the management structure, or as I call it, the governance layer cake. By the way, I asked ChatGPT to create a couple of layer cakes for me to illustrate this this point, and it blew it like it does because it's stupid and it makes mistakes. First of all, I wanted the shareholders in there somewhere, and they're not even in there. And you can see I've got independent above independent contractors and managers above employees, and it's just all a complete mess. So just another reason not to panic yet that AI isn't stealing anyone's job anytime soon, except possibly mine. So all right, so here are the governance documents I mentioned early that you're going to need, and that you're going to see. And you're going to get them from counsel, or you're going to get them from the internet, and they have a lot of important provisions, and you need to be very careful that they say the right things because they will affect your life. In a corporation, we have the articles or the certificate of incorporation. This is where this is the document we file with the Secretary of State that creates the company. And I'm going to talk a little bit about the important provisions that should be in it. Then we have the bylaws. Bylaws are, a set of rules for how things work at the governance level of a company. Riveting document. If you ever have insomnia, go grab a set of corporate bylaws and start reading, and you'll be asleep in 5 minutes. Literally, the rules for how to call a shareholders meeting, and what a quorum is, and how a vote is conducted, and same with a board meeting and things like that. So the bylaws are, important, but not terribly interesting. Then, of course, the shareholders enjoy participation in the stockholders agreement, and then there are agreements that actually issue stock or that have you purchase stock. It is important in the beginning stages of your company to recognize that purchasing your equity is preferred over granting your equity to yourselves without actually paying for it. And the reason for that is a tax reason. If you hold your equity in your corporation long enough, 5 years, 10 years, then when you sell it, when you exit, you can enjoy what's called qualified small business tax treatment, which can dramatically reduce your capital gains tax. The capital gains tax in the United States right now is 25%. So if you sell your if you sell your company for $100 million, you're going to pay $25 million in capital gains tax. If you have qualified small business tax treatment, you can reduce that substantially, sometimes down to zero. So the thing about it is, qualified small business tax treatment is only available to you if you have purchased your stock in a C corporation. Not a corporation that's taken the S election, not an LLC, and not stock that has been granted to you, but you must have purchased your stock. So the good news is you can do that in the early stages of your company. It's not worth anything. Whenever we form the company, we set a value on the stock called par value, which, as I'll explain in a minute, is roughly 1/10,000th of a dollar. So you can buy 1 million shares of your company on the day it's formed for $10. So that's the trick, right? Is you pay par value for the shares before the company actually has any valuation. In an LLC, the governance documents are the articles of organization, the operating agreement, and the unit issuance or purchase agreement. Equity interest in an LLC is called membership interest, and sometimes it's referred to as units, depending on how it's defined in the operating agreement. The interesting thing about an LLC is that the operating agreement basically forms the same function in the company as the bylaws and the stockholder agreement function in the corporation. So that's one of the reasons people like to form an LLC, is it's just simpler. There are fewer documents and fewer legal requirements. Scott, this all making sense to you?
Yeah, so Brent, let me touch on that because keep in mind, he mentioned a couple interesting points. This, QSBS qualification, reduced taxes, if you hold it, for a period of time. That's not only an advantage for you as the founder of the company, that's an advantage to investors in investing.
Yeah.
And if they don't get that advantage, they're not going to be in. That may be a reason why they don't want to be involved. And so this is another reason why setting up the structure correctly from the beginning is extremely important, because again, we have investors all the time that they're assuming they're going to hold it for 5, 7, 10 years.
Yeah,
So if they're going to hold it for that long, they want that capital gains benefit. So
that's
keep in
exactly
mind
right.
that the very important point. The other thing too is that some of these items that Brent mentioned are going to be part of your deal room that you're going to have to put together. You know, an investor is going to want all these access to these government documents, corporation documents. They're going to want to know about your trademarks and other IP. So again, putting this all together in the beginning makes it easier to raise money, because it makes you more legitimate to people wanting to invest money.
Precisely. As I said at the top of the talk, my goal as your lawyer, and whoever your lawyer is should have this goal, is to prepare you for exit at every turn. Even if you don't plan to sell the company, being prepared for exit is a good idea, because you're automatically in tune with what you should be doing and best practices and all that. Having all of these documents in the proper form, in one place, fully signed, fully executed, fully dated. The last thing you want to do is have to backdate documents because you forgot to sign them when you should have, which can be fraudulent and illegal, is hugely important. And so you can't really pluck these things off the internet and expect them to function properly, okay? Because they have quirks and they have subtleties that may be death to you if not handled properly. So yeah, I think it's important to take this very seriously. And as Scott mentions, you're going to survive due diligence at some point. All right, so here's what I consider the sort of VC-backed company standard. Okay, if you're preparing your company for professional venture capitalists, here's what some steps you need to take to make sure you're looking good to them when they come look. Let me say this, by the way. As I mentioned on qualified small business tax treatment, you have to have purchased your shares in a corporation, a C corporation, and you had to have held them for that long. Okay, so if you start with an LLC and you own the membership interest in the LLC, and 3 years later you convert it to a corporation, the clock starts ticking only when you purchase the shares in the corporation. The LLC time doesn't matter at all. So
That's a great
another
point.
reason, right?
Excellent
Another reason to do that early. All right, so here we go. Form in Delaware, as I've been clear. Just do it. It costs a little extra. You're going to kind of charge you $150. You have to have an agent for service and process that you're paying $100 a year for to be there in Delaware, in case people want to sue you, which they all do, the rat bastards. But you got to do it. You got to form in Delaware, and then you got to qualify as a foreign corporation doing business in Florida or your home state. Now, why do you have to do that? Because you're not in Delaware. You've formed the company in Delaware, but it's domiciled wherever you are. Now, you don't really need to qualify as a foreign entity. Foreign in this context means out of state, by the way, not out of the country. You don't need to qualify as a foreign entity in your home state until you've done some important things, until you're really doing business in the state. Just sitting there hacking away and doing some code is probably not enough to require you to qualify as a foreign entity. Hiring an employee is. Hiring an independent contractor is not. But hiring an employee and paying employment taxes, that's when you trigger the state's interest in having you qualify as a foreign entity. Opening a shop, opening a storefront, doing significant number of deals from a desk in the state can rise to that level as well. But the definitely 100% triggering factor is always hiring your first W-2 employee. In the certificate of incorporation in Delaware, which it's called the certificate of incorporation in Delaware. Every other state in the country calls it the articles of incorporation, which gets a little confusing sometimes because certificate is overloaded and sometimes refers to the stock certificate that we don't really issue anymore. But I digress. All right, authorize 10 million or so shares. Give them a par value, as I say, of 1/10,000th of a dollar. Those will be your common shares. There's generally no reason to authorize any preferred stock at formation because there's just no need for it. When the investor comes to you and says they do want to do a deal, they'll give you a term sheet. That term sheet will describe the stock that they want to purchase in your company, and you'll go then file amended and restated certificate of incorporation to create that stock in Delaware. So that you can then sell it to those investors. It's called preferred stock because it has a bunch of contractual rights called preferences associated with it. Like, for example, they get paid back first and they have the right to buy more and all things like that. Rights that aren't necessarily applicable to the common shares. You may want to issue some non-voting shares because there may be people that you want to sell non-voting shares to. When Google was formed, they sold all non-voting shares to their investors. They were such an attractive investor target that management kept the voting shares, and they sold non-voting shares to Silicon Valley investors because it was such a hot topic. So if you have that leverage, good on you. It may be something that you've considered issuing yourself super voting stock. I'm going to issue myself stock with 10 votes per share instead of 1 vote per share. You may consider other things, like I'm going to sign an employment agreement with my own company that says that I can never be fired, for example. And those are all fine things to consider because, as I will mention, or I might as well mention it now, I've never met an investor, and I'm sure Scott can back me up on this. I've never met an investor who wasn't at least a little bit predatory. Okay.
Right. And that's a really good point, Brett, because it's important that you know these items and know some of these terms, because let's be honest here, investors are not doing this from an altruistic standpoint. They're looking to maximize the return of their money and or their limited partners' money. So again, it's really important to understand these items. In fact, at the end, as I mentioned before, I have a whole glossary of investment terms that investors will sneak into an agreement, or they'll want terms, in that term sheet. You need to know this,
Yeah.
or having a great advisor like Brett to walk you through that.
Yeah, absolutely. Some investors are a lot predatory, and they will take advantage of every opportunity they can. It's an ROI transaction for them. It's a monetary transaction. If you're making the world a better place, great, please do. It could use a little betterment. But that's kind of ancillary to many investors. It's all about the ROI, and they will take whatever they can get from you. And that's not to say you can't be friendly with them. And goodness knows, hopefully they're contributing some value to your company and sitting on your board, or your board of advisors at least, and actually adding value. And you share the interest that they have in, frankly, creating wealth for yourself. So it's not, all that bad. But do recognize, however, that if you think about issuing yourself some super voting shares, if you do sign a contract with the company that says you can never be fired, that's still all negotiable, okay? So you can protect yourself, but if I come along and I'm about to write you a $10 million check, I can restructure that. If you want my money, you're going to listen to what I say in terms of restructuring your fancy super voting stock, or your can never be fired employment agreement, or what have you. Because if you want the money, sometimes you gotta bend and do the deal and negotiate points away. So I caution people against making this process unduly complex at the beginning out of a sense of protection. Just keep it simple and do what the investor expects to see. Look, if you turn out to be a Google and you can command whatever you can command, great. We'll do that deal all day long, and they can bow down to us.
And I'll add, though, obviously, you want to make sure you're as, investable and amenable as possible. But at the same time, you have to be aware that the investor may require super voting rights or different preference items. You got to be very careful about that. And, there's a famous one just in the news not too long ago. DraftKings, was a famous startup that sold for multi-billion dollars. The founders, by the time they got liquidation preferences and everything else, got nothing from the sale of that company. So again, it's really important to know that don't make it too onerous for the investor, but be aware they may make it too onerous for you.
Yeah, and you can't do a deal that's going to shut you out. Absolutely. And so there's always going to be a balance and a give and take. I had a client years ago that's still in existence, actually. They were 3 years out of the gate. They got an offer from Yahoo to be acquired. And the co-founders would have taken home a paycheck on exit that was, let's just say, X million dollars. It was actually X hundreds of millions of dollars, but it would have been a good day. And they said, no, we're not ready yet. We want to stick around for the billion. We're going to keep growing this company. We're going to turn down this money. And so they went another 5 years before they eventually sold the company. But during those 5 years, they had to take in more VC and private equity in order to grow. And when they finally sold the company, guess what? The take home for them, X. Okay, maybe X plus 10% or something like that. But some days a bird in the hand, right? They would have been multimillionaires years earlier if they'd just taken the first good deal that came across. And you're going to want to, all right, so back to your sort of your VC-backed company standard. You're going to want to allocate some percentage of the cap table to your employee incentive option plan. Incentivizing your employees with ownership equity is always a good idea. We can talk a little bit more about that later, but you can allocate up to 15% of the stock in the company to the employee incentive plan. You don't need to put all 15% there in the very beginning. It's more like 5 or maybe 10. All right, there's going to be a set of bylaws, as I said, riveting document. You need to define the board of directors. I generally advocate an odd number of directors going forward because it's going to matter that you don't need a tiebreaker, that you don't deadlock at the board level, that there's always someone who can be around to break a tie. Having said that, in the early stages of your company, if the co-founders are in a dispute as to how to go forward to the point that there's a deadlock at the board level, maybe 2 and 2 or even 1 and 1, then you may not have a functioning co-founder team, okay? Because you generally need to be in harmony and in consensus at the management level of your startup, especially in the very beginning, with respect to major strategic decisions. So if you need a tiebreaker at the board level very early in your company's history, you may have picked the wrong co-founder. So just heed that. And with respect to how shareholders are treated in the bylaws, I just have one thing I really like to eliminate. And don't always do it, but because sometimes the clients want it, is called cumulative voting. It's as I say, shareholders primarily vote on one thing, and that is the election of the board of directors. Cumulative voting makes that a little more favorable to minority shareholders. They can stack their votes and vote all of them onto one seat, and I consider that somewhat unfair, so I don't like it. So I prefer to take no cumulative voting rights in the bylaws. With respect to stock issuance, it's got to be subject to some kind of vesting, okay? The Silicon Valley standard for rank and file employees is that if you're coming into the company, we'll give you X thousand shares of stock, but you're going to be on a 4-year vesting schedule with a first-year cliff. That is to say, from the day you are hired, you will not vest any stock in the company or options or what have you until the first anniversary of your hire date. If you're still here on that date, we'll vest the first year's worth of the 4-year vesting schedule, so 25% of your equity grant, and then you'll vest monthly on sort of the next 36 months, 1/36 of the remaining amount every month. Why do we do that? Because we want people to stick around, and we want people to stick around and not just come in, get stock, and leave. Same is true of the co-founders, okay? I have had clients vest the co-founders and not vest the co-founders' equity. Sometimes when investors come in, they will want to revert the co-founders to a vesting schedule to make sure they stick around for a while. Look, it can go wrong. I had a client who we had 2 co-founders. They split the company 50-50, and they fully vested on formation. And about a year in, one of the co-founders said, "Yep, okay, I'm done. I've spent a year here. I don't have any more time for this. I'm going to go back to my day job. Make me rich. Goodbye." And the other co-founder said, but I need you. We need another 2-3 years out of you. And he said, "Sorry, I'm fully vested. I don't have any incentives to stick around anymore," which is dumb because you do. It's your company. You want to stay involved in it. But that's the risk you run if you don't vest founder equity, is that someone's not going to have the stomach for it, or life's going to change, pregnancy, marriage, drug problem, what have you. You need to contain that and make sure that somebody doesn't run off with a half, a third, or 20% of your company who's not participating in it any further. All right. So then, of course, we got the stockholders agreement, which it governs the relationship among the shareholders and generally says, like, you can't sell your stock without offering the company or the other shareholders a right of first refusal, and a whole bunch of other things with respect to what you can do with your stock. Suffice it to say that the stock that you own in your privately held company is not terribly fungible. It is restricted. You can't just go out in the market and sell it to other people. The company doesn't want that because the company wants to pick its shareholders, and they pick you, and they don't want to pick somebody else that you might sell it to. Same thing is true of what happens when somebody dies. Does the equity go to the surviving spouse, the estate, the children? Suddenly we've got those people at our shareholder meetings. Or does something change? Does it become non-voting, for example? Does the company have the right to buy it back at fair market value or what have you? These are all things these are questions that we ask and conversations that we have before we draft any of these documents. I'm going to switch now over to the S election and just tell you what the S election is all about. You're not going to pay any attention to this if you're looking for VC, but if you're not, it's important that you know what this does. It's a tax election. You file Form 2553 with the IRS, and it causes the company to be taxed like a partnership. As I said earlier, if it's a corporation, it will destroy qualified small business tax treatment. You must purchase your equity in a C corporation, not an S corporation, if you want the capital gains advantage. Normally, a corporation is taxed on its income, and then it pays you, and you're taxed on your income. So you can, in some instances, get double taxation. Taking the S election moves the income tax to the shareholders, which means the company doesn't file a tax. It files a tax return, but it doesn't get taxed at all on its income, and the shareholders are taxed on the company's income as though it were theirs. An LLC is automatically taxed as a pass-through entity, but taking the S election at the LLC causes it to be taxed at the lower corporate rate. So even if you have an LLC, you can file an S election on your LLC. Turns out I've already talked about founder equity vesting. Got a little ahead of my skis there. So nothing much more to say there other than please consider it and please do it. So meet the SEC. No, not that SEC. This SEC, the Securities Exchange Commission. I'm in the South now, so I have to inject a little football humor into my presentations once in a while. The Securities Exchange Commission was formed in the 1930s, after the great crash of 1929, because one of the things that occasioned the great stock market crash in 1929 was a lot of fraud happening in the sale of stock. People were out in the street saying, hey, you want to invest in my company? And taking money from widows and orphans, and they didn't really have a company, and they were committing fraud, and they just took your money and ran away. So the Securities Exchange Commission was invented to help regulate the sale of stock. It is an area that is fraught with risk. It is one of the areas in the law where, and I say this somewhat tongue-in-cheek, you are presumed guilty until proven innocent, okay? If you are selling stock to people, you have a lot of compliance you need to do. You need to follow the rules, and you need to do it right. And if you don't do it right, you're potentially going to jail, okay? Because you can commit crimes when you're selling stock to people. You can't take investment capital from people who are not wealthy enough to lose the money or not well informed enough to appreciate the risk. The people who do meet those qualifications are called accredited investors, and they're very easy people to sell stock to. If you want to sell stock to people who are not accredited, like Uncle Billy, who wants to give you $10,000 out of his retirement fund, you got to jump through a lot of hoops. You have to get audited financials and then a major disclosure document and spend a lot of money on people like me to prepare all the things you need to do to sell stock to an unaccredited investor. And there are many, many, many other things that you can do wrong when you're selling stock to investors, and you've got to really understand what the rules are and make sure that you comply. Moving on now, you've probably heard of the convertible note. You've probably heard of the SAFE. You've heard of stock, and your question is, why would I sell one of these things to an investor? The situation is as follows. If you're asking an investor to come into your company, you need to give them something. What are they getting? They're getting a piece of the company somehow, and that's generally the equity. But how do you value the equity? You have to give it a price. You have to give your company a valuation. But as we've said, your company's worth nothing from the day it starts, unless you yourself have put a bunch of money into it or a bunch of pre-existing assets or something like that. Your company has no valuation, and it really won't have a valuation that we as the market can agree on anytime soon. So we invented years ago something called the convertible note, which is, investor, we will take your money as a loan, and then once we have a viable market valuation, we'll convert that loan to an equity purchase, and we'll give you a little break. We'll give you a little discount off the valuation because you've been here for so long. And then people realize, the note's bunk. The note is fiction. Nobody ever pays back the loan portion of the convertible note. Let's just do a SAFE, a simple agreement for equity, which is, I'll take your money today and I'll give you stock tomorrow when we know what it's worth. That's basically what a SAFE says. And there are some preferences and some discounts and things like that. But again, it's all because the company doesn't have a valuation. So you tell people, yeah, I'll still take your money. Someday I'll have a valuation and I'll convert your money to equity. When will we have a valuation? Here's the joke. When a very smart person says you should. When a Series A investor comes along and invests more than $1 million into your company, typically that's the trigger, because some smart investor has decided that you're worth $10 million or $3 million or $100 million, and that's your valuation. Is it chicken entrails against the wall? Yeah, it's a little more formalized than that, but for the most part, it's somebody who wants to invest in you deciding what you're worth. And that's when all the safes convert and the convertible notes convert. And then you sell, then from then on, you're selling stock, you're selling equity at a price. All right, moving on to my last couple of slides, pitching and due diligence. This is really just some important pointers to sort of bring everything that I've said all together. When you're pitching investors, when you're pitching, you know, somebody to acquire your company in an M&A context, the message is that you're trying to convey is we've invented a money machine that will turn your dollar into $100 within 5 years. You might say 36 months, you might say 18 months, but you know, the investor is kind of expecting to exit within 5 to 10 years for the most part. And that's the pitch. If you give me money today, I'll give you a ton of money tomorrow. And now let me show you how that machine works, right? And that's the rest of the pitch, is here's how my company works. One of the messages it's very advantageous if you can truthfully send to your investors is this is a growth opportunity. This is not a concept opportunity. I've already proven the concept, all right? I already have customers. I have performed solid market validation. I've done surveys. I've got beta testers. I've got people who've swiped their credit card and prepared to buy this as soon as I finish building it. This is a growth opportunity, investor. I've already proven that people want to buy this. I'm going to use your money to build my company so I can sell to more of those people. That's the message the investor wants to hear. Seed investors, pre-seed investors, friends and family, people who just love you and want to help you out. They don't necessarily need to hear this because they just want to be a part of your company and help you out and maybe get rich someday. But any serious angel or VC is more inclined to invest in a growth opportunity that has been fully validated. And I will just take a moment to say, about the worst thing you can do in terms of wasting your time and the time of your co-founders and your spouses and the people who are depending on you to do a startup company right, about the worst thing you can do is not go out to your customers and confirm that they will buy your thing once you've made it, right. Okay? You're just wasting everybody's time. You're like, I think this is a good idea. I know I would buy one of these. I'm sure everybody else is going to love it too. Great, you may be right, but that's an assumption that you're making and you need to validate it. You need to go talk to your customers.
So, Brett, we got about 5 minutes left. I want to touch on this piece from 2 standpoints. One, as I mentioned, I'll put it in chat again. We have for everyone on the call a pitch deck template and a list of things that investors are going to require in due diligence. So again, obviously there's more information than what Brett has, but I want to make sure you get those resources. So I'll say at the end of the chat. And one thing I will say about one of the first things I learned very early in this business, I was told from a seasoned professional when I was all of 22 years old, is that you know, if you want to enjoy Thanksgiving dinner, don't invest in family money. And so again, friends and family may be where you start, but there's a word of caution there. You know, make sure they're probably, in all frankness, they're probably the ones that should deserve the most amount of disclosure, because in all frankness, if anyone has a brother, sister, aunt, or uncle, you know, one dispute can, you know, fire up some emotions. And I would, again, a word of caution and a word of advice from that.
Let me add a couple layers to that. I have never known a startup company where there wasn't a little bit of tension, at least a little bit of tension between creative or engineering on the one side and business on the other side. Okay, it's almost endemic. It just happens. There's going to be disputes and different perspectives between those two camps. I have never met a startup company with friends on the co-founder team who stayed friends or stayed as close friends as they were when they started the company. There are some exceptions. If the company tanks and doesn't quite work, well, no big deal. They generally stay friends. But if the company enjoys a measure of success, for whatever reason, the friendship begins to dwindle in favor of the corporate enterprise. And it's a shame, but I see it all the time. Just a couple more points. When pitching investors, Never, ever lie. Not even a little, not even by mistake. If you lie, it's fraudulent. You've committed stock fraud. You're taking the perp walk. If they care, they come after you. They undo the deal. They get their money back, and you go to jail. How do you lie by mistake? Well, for example, I've seen of people who say something like, "We own the patents in this space. We own the patents in this space. No one can compete with us." When in fact, they had filed one provisional patent that's not even a patent. Okay, so just again, you as the leader of the company need to know all the subtleties of all the things and what they mean. You need to know that a provisional patent is not the patents in the space. Okay, so you have to verify the veracity of everything you say to investors. And on that note, don't just show the sizzle. Talk about headwinds, talk about problems, talk about your competitors and the really good ones. And wow, I really love these guys because they're doing amazing stuff over there and we're going to have a hard time competing with them. Be realistic about that. Okay, investors don't want you to blow smoke up their butts. They want to know the trouble that you're facing. They prefer candor and reality. And given that we only have 4 minutes left, I will close at this point. I'm sorry if that's not all readable, but this is brentbritton.com if you want to check out my website. And you're welcome to send me an email or call that number, which is really dark down there, but it's.
I'll make sure everyone gets your contact information. Don't worry about that.
Thank you.
So again, we have a couple of minutes left. Yeah, if you have a question, just throw it in the chat. We had a couple of questions from some of the previous slides. One was regarding trademarks. The question from Isabella was, are trademarks a federal item or is there obviously a state item as it applies to trademarks?
Yeah, so there are state trademarks and there are federal trademarks. The state trademark is well, and there's also a common law trademark, which is if you are using a brand in commerce, you own that trademark, okay? And you can sue people for infringing that trademark if they're using a confusingly similar brand, but only where you yourself are also doing business, okay? So if you're in Central Florida and somebody's in Podunk and they're using a confusingly similar brand and you don't have business in Podunk, you can't sue them. If you get a state registration, you can sue people throughout the state, whether you have business there or not. And if you get a federal registration, you can sue people throughout the United States and its territories, including Guam and Puerto Rico, who are infringing, whether you have business there or not. So the astute entrepreneur will go ahead and obtain both the state and the federal trademark. But if you get the federal, that's 99% of the issue.
Thanks for that. And in kind of a similar vein, there's a question. Obviously, you've referenced, Florida law and Florida, domicile. But the question came is, what about other states? As you mentioned before, you should refer to, the regulations, requirements within the state you're doing business.
Well, I would say this: practically everything I said today is federal. Okay, practically everything I said today is either Delaware specific or federal. I actually said nothing that was specific to Florida. Other than, many of my clients, I'm admitted to practice law in California, New York, and Florida, but since I live in Tampa now, most of my clients are here. So that you can almost ignore the word Florida in this presentation and insert your state here, and it's still true. Okay, so most of it's Delaware though.
So 2 more questions. I'll take a stab at it. You can jump in, Brett. Question from Sarah was convertible note versus safe. When can you take the money? In my experience, we're doing a safe note right now, and basically it is a rolling close. So there's not necessarily an escrow requirement. That's one of the advantages of that. But again, there may be some instances where, there is going to be money put in escrow. Do you want to share some more flavor on that, Brent?
Yeah, I mean, so around the country, a lot of investors have heard of the convertible note. There are still investors, there are still sort of old timer investors who don't even convertible note. What? I want my stock. I want my stock certificate. I want to put it on the wall and then tack it up there. So you can run into problems where people don't understand a convertible note and definitely don't understand what a safe is. If you're in Silicon Valley, you can sell a safe all day long. If you're in Boston, it's 50-50. If you're in Florida, maybe. But I don't like rolling closes. I don't like tranches. I'm like, if you want to invest in my company, you should give me the money. But I understand that there are investors who certainly have, you hit a milestone and I'll give you more. My problem with that is they should get a worse deal down for the downstream tranches because I'm getting more valuable every day.
Absolutely. Yeah, again, and a couple of questions regarding, obviously some other states you can incorporate. You can incorporate with your home state. There's talk about Wyoming and others. Yeah, this person asked about Texas, Montana versus Delaware. You want to share some?
Again, if you want professional venture capitalists to invest in you, be a Delaware C corporation,
Yeah.
period.
I
Can you find one who won't care? Yeah, maybe there's a non-zero chance of that, but for the
and
most part,
what I want to do is keep in mind your job is to create as many reasons to invest, but prevent as many obstacles to say no.
yeah,
So
exactly.
again, if an investor says you need to be a Delaware C corp, don't argue it. Just become a Delaware C corp
Yeah,
because
if you want their money, yeah.
it's the golden rule. He who has the gold makes the rules. And so again, be pragmatic about that. I think we had one more question. So in terms of structure, they asked about having a C corp. I think the question is maybe having a C corp for the parent company and then LLCs under that umbrella. What do you talk about that?
My response to stuff like that is keep it simple, stupid.
Thank you.
If you've got some concept in the future where you're going to have a holding company and different operating companies, great, you get there someday. Okay, most investors don't want to see undue structure and undue complexity. They want to invest in one thing and understand it and get it going, and then we can move on to the future.
And let me talk about that from the mindset of the investor. Okay, if you have your C corp that you're raising money and you have this LLC that has other assets and it's taking your time, as an investor, I'm going to say, okay, why should I invest in the C corp? If I'm putting 100% of my money in the C corp, why aren't I getting 100% of your assets and your time?
Right.
And so you have to really understand it from a pragmatic standpoint. There's a lot of entrepreneurs that try to be tricky about that. Oh yeah, I'm going to put some assets over here, but I got my own little piggyback over here. Believe me, that'll come up in due diligence.
Yeah, absolutely. I got this patent portfolio and I'm going to license it to my company, but I'm going to keep ownership of it myself. I'm not investing in that company. Right. I want the company to own its patents. It's like hiring an employee that says, this job is just a stepping stone for me. I'll be gone in 6 months. Yeah, okay, bye. Don't bother.
Exactly.
Don't bother.
Well, with that, I want to first of all thank everyone for being on the call today. I just shot in the text my email address. I will do two things post this event. I will send out the recording of the event. I'll forward the slides if Brett allows me, and I will send forward his contact information. And again, as I always end these calls, if there's something you didn't like, tell me. If there's something you like, tell everybody else. And with that, Brett, thanks for being on the call today.
Yeah, thank you, everybody. It's an honor to have taken an hour of your time. I hope you found it useful, if not entertaining.
Thank you.
Thanks, Scott.